It was very interesting when you, hi Mike, when you
Hello.
got in touch with me about the Confession Killer documentary.
Right.
I mean, that was incredible, wasn't it, with Henry Lucas?
Yeah, I loved it. I mean, I didn't want to watch it. I still, despite how great Making a Murderer was, I still really don't gravitate toward these law shows. I have
Yeah,
watched more documentaries, and there are some that are really good, and some I don't like much. And this one, I thought, well, it's interesting. It's a little bit run of the mill, but then it just really got better and better the longer I kept watching. And I remember watching them all in one evening. It was just fantastic. I couldn't believe some of the stuff that was happening in there. And then I talked to Larry White, or emailed Larry White about it, and
yeah.
he pointed out how that was just in a different time, back before anyone knew anything really about false confessions and why people might do that. So I don't know the time period that was set in. Was it the late 70s, early 80s, something like that? That might have
Something
been.
like, oh yes,
Yeah,
yes, yeah. It's gone back a while, isn't it?
yeah,
But no, I mean, I still remember some of the characters in there. The sheriff was called Jim
yeah.
Boutwell, the Texas Ranger, and
Right,
you remember that he was the district attorney, Vic Fazell.
right, right. I,
Um,
I
I,
loved how in the end they had this woman all coached up to say that
yeah,
he was still alive. I mean, it was just amazing. Just a great documentary. So that one was a lot of fun for me, which I didn't expect, but I really enjoyed it.
but you raised the question, didn't you? Can false confessions be humorous? Well, there was a it's a serious issue, but there was a lot of humour to that, wasn't it? Ridiculous and sort of laughable. That
Yeah, the first level is you think, well, these cops are so dumb, they're getting what they deserve. They want these confessions. The confessions don't hurt him, and he actually, the one kind of did, because it resulted in a potential death penalty. But aside from that, it's like he's benefiting from it. You usually don't see that. Usually it's the cops trying to get these confessions. But then on the other hand, you think, well, all these, once you think about it sober, in a more sober light, you think, well, all these people are then going unpunished that are actually committing these crimes. So, but there is a humor element to it. There's no question. I mean, I was laughing out loud during parts of that documentary. That was great stuff.
yeah, yeah. I mean, Henry Lee Lucas as an individual, when he went to that, was it just an arraignment? And he said, that's fine about the two murders that I've done, but what about the other hundreds that I've done?
Right.
You know,
Unreal.
and I
I'm
remember,
imagining that's relatively rare, though, where someone just, I know it happens. Obviously, it happened there, but I would say in the majority of cases, it's the police that are prodding and poking and looking to get something to benefit the government. And here, this guy was just offering everything up and was having a good old time, including the strawberry milkshake. I think he enjoyed on a
yeah,
daily basis.
and was it, what was the cigarettes that he, something palm or something mild, was it?
I don't remember, but I remember his teeth looked like he was a smoker.
Ah, yes. Oh dear, oh dear. And then the efforts to in the end, was it not one of the George Bush that was the governor of Texas at the time, and he actually commuted the death sentence for him because they were able to prove that he hadn't actually done this one crime.
Right, right. Yeah, I was surprised to see that too. I don't remember of any of that unfolding live back in the day. I was around and old enough to remember, but I just don't remember it. So, but yeah, I was surprised to see George W. Bush on there.
Yeah, yeah. And I suppose one of the questions that you would ask is that there were these mothers that got together who had lost loved ones,
Yeah.
and advocating so strongly that Henry Lee Lucas be put to death, when in actual fact he was innocent of all but two of these murders.
Yeah.
I mean, can advocacy go too far?
Well, yeah, I mean, we've seen it. Certainly it can. I mean, people get they make up their mind one way or the other, and it's very difficult to change it, which kind of leads into one of the things we'll talk about, the burden
Sure.
of proof and things like
Yeah.
that. But yeah, I mean, and then you saw the odd thing in that documentary was later on, you had a group of mothers and parents of these crime victims who are advocating for this guy's innocence because they didn't want the opposite. They realized, hey, this, it'd be nice and convenient to say, okay, they got the guy, but this isn't working out, and they were treated pretty harshly. by law enforcement because that didn't fit with their didn't mesh with what they wanted. But yeah, interesting stuff. That was a lot of fun.
Yeah, yeah. So anyway, talking about watching documentaries, I suppose the closing arguments at Steve's trial around about episode 7 of Making a Murderer, and I suppose by that time I'm getting kind of used to the sort of crass comments, but the one that really fired me up and really did annoy me was the one that you're going to tell us a bit about just now. The reasonable doubt is for innocent people.
Yeah, Kratz. What was the quote? It said, he said, convict this guy. Reasonable doubts are for innocent people. That's a part of a bigger problem. And many trials, I'd say maybe half of my trials, and certainly this happens all over the country, prosecutors love to diminish that burden of proof.
Yeah.
What Kratz was asking the jury to do is say, well, of course, the burden of proof and reasonable doubt and all that, that's the tool or the framework we use to decide whether to vote guilty or not guilty. What Kratz is doing is say, well, set all that stuff aside. All right, this guy's guilty. Now that he's guilty, let's determine his guilt, and then we'll set aside the very thing that's supposed to be used to determine that guilt in the first place. It's very crafty. These arguments these prosecutors use, they always have many ways to do this. I jotted down a couple of my favorites here we can get into, but what they always have these very crafty things that they're intuitive, or they have a nice appeal on a knee-jerk kind of intuitive level, and they always try and reduce that burden of proof, because the burden of proof is very high in criminal cases, proof beyond a reasonable doubt.
Yeah.
You can think of burden of proof along a continuum. There's at least 4 easy ones to think of. One is probable cause. There's actually at least a couple levels of that, but probable cause just means that is there a plausible, scenario here that constitutes guilt. Roughly speaking, it's framed differently, but the police often use that to arrest. The preliminary hearing bindovers are based on probable cause. And then there's the standard of proof we use in civil cases that we call the preponderance of the evidence. So a lot of times people think that if you were going to weigh the evidence, it'd be 50.1%, just barely over 50%. And then in some cases, like if you're trying to take away someone's parental rights, which is non-criminal, but it's more serious than just getting sued for like a breach of contract or something. Sure. If you're going to do that, the standard of proof is often clear and convincing evidence. And then criminal, it's the highest of all, proof beyond a reasonable doubt. And that's why prosecutors often set out with the mindset, we got to diminish or reduce that burden of proof. And that's what Ken Kratz was doing there. And they're very crafty. They've developed lots of arguments to do it. They're often challenged on it. Rarely there's any success in Wisconsin on it, but that's one of their primary goals.
I was going to say, is it not up to Patrick Willis to give Ken Kratz a slap on the wrist and say, you can't say that because at the moment Stephen Avery is innocent. He's innocent till proven guilty. Usually
when these things come up on appeal, they blame the defense lawyer for not objecting. Mm-hmm. When the defense lawyer, and then what they do is they say, well, the error is waived, defense lawyer didn't object. Now the defense lawyer, in this case, Buting and Strang, and they were in a very tough spot because there are real risks to objecting. And often you want to let things go. You don't want to be piping up constantly. You don't want to be drawing further attention to arguments. I mean, after all, the jury is going to get a written jury instruction on proof beyond a reasonable doubt. So is that big of a deal? That these are the things that go through your mind when you hear this prosecutorial misconduct. And so then what the appellate courts like to do is they just like to blame the defense lawyer. Well, he didn't object, and therefore it's waived, and that brushes it under the rug. So some defense lawyers take the approach they're going to pipe up, object at everything, and they're going to look obnoxious to the jury. But at least they protect the record on appeal. And others, you got to make a snap decision. That's one of the toughest things you have to do is make that snap decision in trial when you hear the prosecutor cheating. Now, I've written an article called Constraining Strickland. Strickland is a case where, let's say a defense lawyer doesn't object. The appellate lawyer might go after him and say, Strickland says you were ineffective. You didn't render effective assistance, and we blame you for that. I believe, getting back to your original point, I believe that the judge, when a prosecutor cheats or a judge makes an error. In this case, I would call it more prosecutor cheating because the judge isn't doing anything. He's just sitting there. I think in those cases, because the prosecutor and the judge also have ethical duties toward the defendant, the prosecutor is a minister of justice, all that kind of stuff. They have to play by the rules. I think the attack should be focused on the prosecutor, not putting the defense lawyer in the middle of it. Why didn't you object? Because there's always a good reason not to object. So that kind of gets rid of the issue completely. So that's a good question you raised. And I think, is it the judge's obligation to step in? Yeah, he could have. Absolutely, he could have. I don't think it's his obligation. I think it's more the prosecutor's obligation to follow the rules, not diminish the burden of proof. And I believe when these things are analyzed on appeal, it should just be, look at the prosecutor. Think of the message that would send. One prosecutor gets slapped down for this, for diminishing the burden of proof, then they don't do it again. But our appellate courts are afraid. They're afraid to do that. They won't do that.
Yeah. So Strickland is one of those ineffective assistance of counsel cases. Is there another one? Is it Coyle versus Sullivan? That's another ineffective.
Go ahead.
Sorry, I was going to say, has one got a higher burden of proof than the other?
Is Sullivan? You'll have to refresh my memory. Is that the one that came up in Dassey's appeal, and it dealt with the it dealt with more of a conflict. Am I thinking of the right case here?
Yes. Yeah. Len Kaczynski having a conflict of interest rather than just ineffective.
Yeah, that's along the same lines. That's the reason they may have chosen that approach, and I don't know, I don't do appellate law, but the reason they may have chosen that approach is because you don't have to, it goes more to a structural error. In other words, if I'm employed by the DA's office and I step out on the side and go up maybe go up a county where they don't know me and I start representing defendants or something. I mean, that would never happen. But if I'm somehow being paid by the DA's office, I can't then go represent a defendant against the DA's office because I'm employed by that DA's office. Or if I think some other possible structural errors might be, there could be a conflict if you are married to the prosecutor, for example, and you go up against him or her because there's that legal relationship there or something. In cases like that, that's where that other case may come into play because it's kind of I don't want to mischaracterize it. In my mind, it's a bit of a subset of the ineffective assistance, but it's very tough to prove. I mean, I don't think Kaczynski did have a conflict. I think he was just, you could make a much stronger argument that he was behaving ineffectively, rendering ineffective assistance. But then once you do that, you've got to show prejudice to the case, which is the second prong of Strickland. So, I think those two cases would be in the same family of cases for sure.
Sure. Getting back to this burden of proof, though, it's interesting that you mentioned about this. You know, you need this 50.1%. I always remember an iconic statement by Darrell Massey. He was the investigator in the Adnan Syed case. In Syria, and he says, that when it comes to arresting people, he only needs 51% evidence. It's up to the prosecutor to make sure, the conviction 100%, and I thought, wow, that's a pretty low bar if you only need 51% to arrest somebody.
Yeah, you don't even need that. That's a misstatement. I mean, I can only speak to Wisconsin, but in Wisconsin, the test for an arrest is probable cause, which is lower. I mean, that would be like when I laid out those four, that would be the lowest. That's what's needed for an arrest, probable cause to believe that a crime was committed or is being committed, and then for the bind over at the preliminary hearing, it's the same thing. So that's a very low burden of proof. Some of these preliminary hearings are just disastrous. I mean, they present almost nothing. They do it through all hearsay and present almost nothing. And that's sufficient, all inferences to the state, and probable cause is a low burden of proof. So that's virtually that's not even a speed bump. I wouldn't even call that. That's like if beyond a reasonable doubt is a hurdle that you have to jump. This is like a crack on a sidewalk that you have to step over. There's just there's nothing to it.
Sure. So I mean, is there ever going to be a situation where, as you say, somebody is going to be reprehended, slapped on the wrist for what Kratz said? Reasonable doubt is for innocent people.
Yeah, it's funny. I got a friend of mine, attorney down in Arizona, just emailed me this. This is, like I said, there's a lot of different arguments. They're very creative when they come up with these different ways to lower the burden of proof. And here's this great one from Arizona. It's a 2019 case. and the prosecutor said this. When you go back there to deliberate, someone might say, well, I think one or both defendants might be guilty, but I'm not sure of their guilt beyond a reasonable doubt. And the prosecutor goes on, he says, now stop and ask yourself another question at that point. Why did I just say that? Why did I just say that I think defendants might be guilty? You're a fair and impartial juror. If you're thinking that, if you're saying that, is it not proof that you have been persuaded by the evidence beyond a reasonable doubt? Why else would you say that if you are not convinced beyond a reasonable doubt? So here's a prosecutor that's saying, well, if you think he might be guilty, you got to convict. That's exactly what he's saying. Now, This is an Arizona case. What the appellate court reversed it, and they said exactly that. They said that if they're basically, let's see, I wrote the paragraph number down, paragraph 19. They said that, in Arizona, beyond a reasonable doubt means that you have to be firmly convinced of the defendant's guilt. If the prosecutor argued that, well, if you think he might be guilty, that's proof beyond a reasonable doubt. So might be guilty, as the court says here, no, that's more like the probable cause standard. So you're like 2 or 3 burdens of proof away, prosecutor. Now, in this case, the defense didn't object. And the appellate court reversed it. I'll just say the name of the case if anyone's interested. It's the Supreme Court of Arizona State versus Claudius Murray, Murray. It's from 2000 it's filed 2021. It was just filed, so
Right.
he was on top of this when he sent it to me. Yeah, so it's just filed March 18th, 2021. So now to answer your question, you said, is anyone ever going to get spanked for this? Basically. Now, in this case, it was reversed and sent back. In most cases, it isn't. However, even in this case, I'm just shaking my head as I read this. They said, well, the prosecutor didn't commit any type of misconduct. Well, misconduct's a very broad word. So this wasn't an intentional thing. This was more just an accident. So no, there doesn't look, I mean, I didn't read toward the very end to see if anything was referred to the state bar or anything like that for misconduct. I really don't think it was. I think this court basically said that was a accident, and accidents can fall under misconduct. So we're going to reverse it. So prosecutors rarely get rebuked for any type of misconduct. Usually they'll get yelled, the court will chastise them a bit and then say, well, in this case, the error was harmless. Or it'll be, this is a rare case where the defendant actually gets a new trial, and then they really take it easy on the prosecutor. So yeah, they don't get rebuked too often, not even in this case where it was actually reversed. Inadvertent error is what they called it in this case. Now, in Wisconsin, if you're wondering, the prosecutors can get away with a lot more because when the judges instruct the jury on the burden of proof, they give a very defective instruction. I don't think many reasonable people can disagree with that. The instruction itself in Wisconsin, the jury instruction, the jury is instructed on the burden of proof by the judge in a pattern instruction, and the instruction itself really goes to great lengths to diminish the burden of proof. So it's a really bad situation as far as the burden of proof here in Wisconsin.
Yeah, correct me if I'm wrong, but the judge says something along the lines of, although you've got to convict beyond a reasonable doubt, you are not to look for doubt.
Yeah, it's got several flaws. That's the most serious one. It says it concludes after it explains reasonable doubt in a very defective way. And this isn't just my opinion. I mean, if you read it, you might think, yeah, there's something a little wrong with that. And then a lot of other people have studied these things and done controlled experiments on them and stuff. And there are many flaws in Wisconsin's instruction. I think there are 4. The first 3 I won't get into, but the last one is the one that Larry White was the psychologist in Making a Murderer. Yeah. He and I did some controlled experiments and tested it. First of all, you can just tell there's something wrong with it. It concludes by saying that while you're to give the defendant the benefit of every reasonable doubt, and it kind of says the reasonable doubt standard says you are not to search for doubt, you are to search for the truth. Now, there's just some, without even thinking about a controlled experiment or a test of that instruction, there's some real flaws to it. First of all, doubt and truth are different things. Truth is the goal. Doubt is how confident, are you in that decision? And that reflects the reasonable doubt standard. You can't just think it might be guilty or it's probably guilty, or I'm convinced by clear and convincing evidence that he's guilty. So doubt is that it's the measure of how confident you are. And the instruction literally tells you to disregard that. And it also sets the prosecutor up for some great arguments. Here's how this often goes in Wisconsin. The defense lawyer, of course, when he gets his argument, says that, well, there's lots of reasonable doubt in this case. Look, the state's alleging this, but let's look at what the evidence shows. And you go through that and say, yeah, this is reasonable doubt. I'm not here to prove his innocence because I can't do that. We don't have the investigative resources. We don't have access to the crime scene. So the test is, beyond a reasonable doubt. Has the state proven that? No, there's reasonable doubt all over the place. Then the state gets up in the rebuttal and they say, he's trying to trick you. The instruction itself says, don't search for doubt. You're to search for the truth. And then, of course, the prosecutor aligns themselves with the word truth. They align the defense lawyer with doubt. Doubt is the very thing you're not supposed to be looking for. So, like I said, they're very crafty. They've got all kinds of angles. They probably do seminars and training on this because they've developed so many of these crafty arguments that are either in other courts and other states, by the way, have said, yeah, that's illegal. You can't do that. The Fifth Circuit Federal Court of Appeals, the Washington State Court of Appeals, they said, yeah, you can't. Searching for truth misstates the jury's duty. It misstates the burden of proof. The Fifth Circuit says you can't use language like that in a burden of proof instruction. That's prejudicial, reversible error. They're very clear on this, but Wisconsin, we just keep doing our own thing. And this jury instruction committee, which is comprised almost entirely of former prosecutors, they just, they love that instruction that says, yeah, don't search for doubt. That's the jury's exact job, is to search for doubt. You have to, like Washington court says, you have to examine the evidence and the record for reasonable doubt. That's the jury's job. You can't tell them not to do that. That's absolutely insane. If that Arizona case I just talked about is reduce the burden of proof, just think what our instruction does. I mean, it's worse than a prosecutor argument because here the judge is literally instructing them that way. So it's an absolute disaster. Now, does it matter? In some cases, it won't matter. Some cases are either so strong for the prosecutor or so strong for the defendant. It's going to be a conviction or an acquittal, regardless of the burden of proof. But you don't know that going in. And certainly there are a lot of cases in the middle where there's mixed evidence. So I think Wisconsin's an absolute disaster. And not to run on too long here, but there's just so much to say about this instruction. But Larry White and I, as I said before, we tested it. We set up controlled experiments in a case using the case study method. We recruited participants who were juror eligible citizens, and we compared the two groups. We gave one group the Wisconsin instruction without that closing mandate, and we gave the only difference between the two studies. Everything was identical, was that closing mandate. You're not to search for doubt, you're to search for the truth. And we, randomly distributed the test participants to groups. Larry's a research psychologist, so he knows how to do this stuff. And we got significantly higher conviction rates in two studies based on just that closing mandate, without even the prosecutor hammering away at it. So the evidence is clear. Language and logic and now the empirical evidence show that, this is a disaster. I'd love to see what the Supreme Court would say about this instruction, about whether it diminishes the burden of proof, but it's got to get up there. I don't know if it ever will.
Sure. What was interesting then was when you were talking about that, I suddenly remembered. Well, first of all, if I was a member of a jury, I think I would tend to be of the opinion that you've got to prove to me that this guy is guilty if I'm going to vote guilty for this guy. Right. So I suspect in that situation I would be one of those ones that would if certainly in Stephen's trial, I would have been definitely not guilty, quite obviously. But then, I remember that line to do with the finding of the key, and it was Dan Kucharski that said, was it no? It was one of the prosecution people that said to Dan Kucharski, like anybody could have put it there, it could have been aliens.
Yeah.
And that's the kind of reasonable doubt that I suppose, in fairness, they're trying to get rid of. The idea that, if somebody said to me in a trial, if I'm a jury, as you said, I can't prove that the guy is innocent, but it could have been an alien that did it. Then, that's I suppose is what they're trying to get rid of. But it's gone far too far. Is that?
Yeah, that's. I think they did a good job recrossing that. Was it Buting? I think that was handling that witness, and I remember thinking, he did a good job of it. I mean, is that the type of thing you should really have to do anything on? It's so absurd, wasn't it? Just absurd. Yeah. And it makes for a good argument that, hey, look, the state has a burden of proof beyond a reasonable doubt, and here they are talking about aliens. It's just pretty bizarre. But the statement itself you're referring, then that was the key that was first. It was found under something, but it wasn't there the first time they lifted the shoe. That kind of thing you're talking about way back in the yeah.
I actually just after watching Making the Murderer, the first thing I did was obviously checking online for information about it because I was that shocked about it, and I thought, I wonder what's happening. And I got the phone number for the Manitowoc Sheriff's Department. I actually phoned Sheriff Herman and had many long conversations with him. And, and in fairness, like a lot of law enforcement people, they're almost like politicians. They have to be very charming, very polite and friendly and everything. And we had some friendly chat,
Right.
But he said to me this one time, he said, I know you're not going to believe this, but, you're not going to accept this. But you do realize that not all of those 7 searches were for hours long. Some were 10-minute sweeps. And I said, Robert, I can tell by the tone in your voice, you're embarrassed to even bring this up. There were 6 searches. They found the key on the 7th search. That was the 3rd long search for several hours,
Right. Yeah. Dispensing with the 1 search warrant, 1 search rule as well. Yeah.
But anyway, there was something else I wanted to ask you about. Well, a couple of things I've written down here. And thanks for showing us that Arizona Murray case from 2021. But thank you also for sharing with me the case of Demetrius Phillips in Illinois.
Oh, yeah.
Whose confession was thrown out.
Yeah. I think I sent that last time. Right.
And what was interesting there, of course, was the level of threats that the interrogators were making to him about the fact that, when he goes to prison, he'll be killed because he's a child killer himself,
Right.
And I thought, well, yeah, that is a real extreme case. I suppose we didn't quite have the same in Brendan's case, did we? We didn't have the police threatening Brendan with, when you go to jail, you're going to be killed. But
right. Yeah, you wonder how extreme it would have to get to tip. To tip the other way. I mean, if they're, assuming there was a real possibility, but the threats in that case were pretty extreme. And you always wonder, the more extreme the threats get, I always think, what's going through the person's head? I mean, you'd think, okay, so if it's going to be that bad, if I'm convicted, how is it exactly I help myself by confessing to the thing that's going to put me in that situation? It's just crazy, but that situation takes away all rational thought, especially for younger people. But it's the setting of the interrogation is designed to do that, to get you not to think rationally, to get you to think that this is your best option. I just don't see how you would think that it's your best option to confess to the thing that's going to get you into that bind. But that's where the promises of leniency come in, and they're usually not direct. Like, okay, if you confess now, you'll only get charged with 2nd-degree murder, and they'll plead it down to, such and such. Those express promises aren't made, but that implication is there. They're implying that, okay, it's going to be easier if you confess. They never really say how, and I'm not quite sure psychologically how they get the person thinking that. I mean, sometimes there are promises, the judge will take it easy on you and that type of thing, but it just seems, obviously it's very sketchy, but I sometimes struggle to think of the link there, why people, take that to mean, all right, I'll confess and then I'll be better off.
I suppose it was something that was asked of, what's his name? Richard Ofshe.
Yeah.
A famous quote by him, this guy interviewing him, he said, if I'm being interrogated and and they tell me, you need to confess, you'll be better off for it.
Yeah.
And I would just say to them, go away. I'm going to get my lawyer.
Right.
And Richard Ofshe said, yeah, you're the sort of people I never get to see. The sort of people I get to see are not like you.
Right.
That they are different.
Oh, absolutely. Yeah.
Lower income, lower
Yeah.
IQs and stuff like that. So yeah, I'm with you. I certainly wouldn't give in to Wiegand and Fassbender, but Brendan unfortunately did. Although he kind of got railroaded, didn't it? It was just everything just added up and added up, and he was a little bit like Henry Lee Lucas. He just kept going, didn't he? At least he never argued back. That was the thing that I got.
Yeah. Yeah.
Brendan, you're allowed to argue back.
Yeah. Yeah. They
And he
take
just,
those options off the table. At least they do it in such a way that, at least in Dassey's mind, those options weren't available to him. And there were a lot of similarities, now that you bring it up, between him and the Lucas. Obviously, Lucas was looking to, his benefit was he got that strawberry shake every day, cigarettes,
yeah,
the one line, something about drinking gallons of coffee,
yeah,
that kind of thing. So he was angling for some tangible benefits, whereas Dassey was just looking to avoid conflict, make things easier on himself, and get back to class at
yeah.
1:15 or whatever time it was. Yeah.
Yeah, I mean, I've always wondered about his comment at the end of the interrogation when they say you know that you're under arrest, and he says, "Is it only for one day?"
Yeah.
He's clearly conditioned to the idea that he's going to have 2 or 3 interviews per day, and if he passes one, he's not going to be under arrest. So maybe tomorrow, if he does better, he's going to get to go home.
Exactly. And they key that toward, I mean, Weigert and Fassbender weren't terribly good. They made a lot of really bad moves, as I laid out in the Anatomy of a False Confession. But what these interrogators do certainly is they tailor it toward the suspect. I mean, if you're that age, they're going to use different tactics. If you're older and you've got a wife, I mean, I've heard in cases I've had, it's rare to get these suppressed. In one case where I did get a confession suppressed, it was an adult male, but they took a completely different tack. They said, look, your wife, we know she's at home sick. You're the only one that can care for her. If you confess now, you'll get to go home, basically. And if you don't, you're going to jail. Who's going to care for her? She's going to die. So they use a different angle depending on the suspect. And then if a person's religious, they'll play that angle. And if a person is, well, in the Lucas case, he was more driving the ship than the cops were. But, then they used, hey, if it takes a strawberry milkshake, great. If it takes a promise of, you can get home and care for your wife, you're the only one that can do it, great. So they'll adapt, and they'll eventually, when you sit there with someone for hours, you'll eventually figure out, what's going to get them to say what you want them to say.
Yeah. I've got, just chatting away. It's great because I come up with other things that you touch on that I think, no, I need to ask you about this. In Wisconsin, do they have either the Alford plea or anything similar to it?
Yeah, there is an Alford plea. I remember using one once. Most judges won't take it. They won't even take a no contest plea. Judges here, they like to, where I practice at least, I shouldn't say the whole state, I'm referring to just where I practice.
Sure.
But a lot of judges won't even take a no contest plea because they like to say, well, I only sentence guilty people, so admit it or, go to trial. But that ignores the reality that, prosecutors can charge you with 4, 5, 6, 7 crimes or 1 or 2 incredibly serious crimes and plead that down to a disorderly conduct or a misdemeanor or something. Who's not going to take that? That's why I think the no contest plea is great. No contest plea says, yeah, you're, I'm not saying I did it. I'm just saying there's evidence that, if believed, could be used against me and could convict me. And the Alford plea is an assertion of innocence, as you probably know, where you're saying, you're literally asserting that you didn't commit it, but you want the plea deal. To me, both of those pleas, the no contest and the Alford, they reflect the reality of the system, that it's stacked so much in favor of prosecutors as far as what they can charge and how they can negotiate and things like that. It recognizes that, look, sometimes you just want to take a deal because you don't want to go to trial on a 60-year felony. You want to take this deal to this misdemeanor. Maybe instead of 60 years, worst case, you're going to get a 7 months jail or whatever it is. Yeah. So to me, it makes perfect sense. Some judges don't like it and won't accept them. Certainly where I practice, some judges won't accept them.
Sure. I mean, it seems bizarre, doesn't it, that the state, you're agreeing to the fact that the state have got enough evidence to find me guilty, and yet that evidence that they've got is not being put to the test.
Yeah, Yeah, and I just had another thought as you were saying that. I mean, in civil law, we let people do this all the time, don't we? I mean,
Right?
well, okay, there's a settlement, but no admission of guilt type
Yeah.
of thing. Why in this civil comparison, you also saw it in if you go back to those documents on that website for Avery's case, all those documents, Buting and Strang filed a good motion. This is off memory now. I think I got it from that website, and I think it was Strang's work or Buting's work, where they're saying, look, in a civil case, we couldn't have these inconsistent verdicts that they had on Avery. It was ridiculous that they could find guilt on one but not the other. Civil defendants, corporations being sued for money would be protected from that type of thing, or at least would have better protection than a criminal defendant. So it's you'd think if anything, it would be the other way, where someone charged with a crime would enjoy greater protection than someone just being sued for money. As the burden of proof reflects, you would expect that to be the same in other areas and aspects as well, but often it isn't.
Sure. I know this is going off on a huge tangent, but
sure.
Interestingly enough, one of the people that took an Alford plea that was featured on Netflix was Michael Peterson in The Staircase.
Oh, yeah,
And we've got David Rudolph very early on in the documentary talks about the fact that, we in America, you've got guilty and not guilty. He said, but in Scottish law, they've got not proven. And I've actually spoken to a former chief of police, and and I said to him, this not proven. It's that is that a good thing? And he said, well, not really, because people go back into the community. They haven't been proven guilty, but the suspicion is always there that they are. And then it suddenly occurred to me, well, there's not really much difference then between a not proven and an Alford plea, is there?
No, and now that you say that, I'm just having another thought here about
Sure.
that would be a great thing to have, because in America, you're basically have guilty or not proven. The state likes to point out always that, well, when they try and use your prior acts against you in a case, so let's say you went to trial, you were acquitted, they always point out, well, no, that doesn't mean you're innocent. This verdict isn't innocent. It just means not guilty. It means the state didn't prove the case beyond a reasonable doubt. So really, in Wisconsin, probably in most states, if not all states, the guilty versus not guilty, the not guilty, the defendant gets no benefit from that not guilty. Everyone always says, well, it just means we didn't prove it. Doesn't mean he's not, it doesn't mean he's innocent. They always like to draw that distinction. So that would be great to see a guilty, not proven, and an innocent, I think, because I guess you'd be nowhere, because that's really what our not guilty plea is here. But I guess the Alford plea is you're speaking out, maintaining your innocence. I think one of the benefits of that plea and possibly the no contest, I wonder, now I'm kind of speculating here because I don't practice civil law, but I wonder then if a guilty plea could be used against you in a civil case if someone wants to sue you for money, but the other pleas maybe can't be. That might be another advantage. There's a lot of layers to this I'm not really familiar with. If you're practicing in front of a judge, you won't take a no contest plea. It doesn't really matter. You got to enter the guilty if you want a deal. But yeah, good points. I would like to see another layer of verdict in there. I think that would be good. Plus, now the defendant's got something better to argue, something more appropriate to argue. Because when you argue, well, the state just didn't prove it, a lot of people really don't like that. But, especially when the judge is telling them search for the truth. Well, if you think something is probably true, what are you going to do? You're convict, Yeah. So I think that would be a good distinction, but it's not going to happen. That won't happen here.
Yeah, I think for most people in Scotland, the advantage of not proven is the fact that it does away with, in certain circumstances, double jeopardy, whereby somebody can be retried for something.
Oh, you think that under a not proven they could be retried?
Oh yes, that's okay. Exactly why it's in Scots law. I'm sure that it's so that you can avoid double,
so you never get any closure. Then I mean, they could always keep investigating, can take a second kick at the cat. Yeah. Double jeopardy here is that's certainly one protection. Although you can find a lot of cases where the state will just change the charge a little bit on you and then try and get you on something else. But there still is some double jeopardy protection with the not guilty for sure.
Sure. Finally, I was just going to just touch on what we were talking about right at the start there about the tweet, the legal watchdog tweet about the fact that these legal universities, there's apparently this desire from some people to have get rid of entrance exams for people coming into law universities. I mean, I just don't understand that at all.
Yeah, there's law is a profession like medicine, but it's not nearly as good. In other words, but it's still a profession. I mean,
Sure.
there's still some correlation, I think, between your entrance exam and your performance in school. There's still correlation between your performance in school and whether you're going to pass the bar exam and things like that. But yeah, there is a movement. I think it falls under this branch of critical race theory or whatever. It's the American universities are incredibly leftist, including the law schools. And there's a movement now. I don't know how popular of a movement is. I'm looking for it right now as we talk. But now that you mentioned that aspect of it, I do remember that article. And a lot of people are saying, yeah, it's basically racist to have an LSAT, law school admissions test. It's racist to have grading. It's they want but in the bar exam too is under attack. People want to get rid of that. Now, I'm in a state where if you graduate from Marquette or UW, the two law schools, you don't have to take the bar exam. Wisconsin is, to my knowledge, it's the only state left like that. Now, I've never viewed that as a problem for me. I remember, out of college, before law school, I passed the CPA exam, which is a much tougher exam than any bar exam. So I don't have any, self-doubts about it. I know the bar exam would have been a pain and, I would have passed it. But putting aside that anomaly of Wisconsin, there's a lot of states where now the bar exam is under attack. So basically they want people to be able to practice law with no entrance exam, no grading, no bar exam. And it's under these racial equity theories. My view is law has to be treated somewhat like a profession, somewhat like medicine. I want my doctor. I love my doctor. I want my doctor to be, to be smart, to have passed the boards, to have gone through continuing education, to have gone to medical school, done well in medical school, all of that. So yeah, there's some movements like that in the U.S. I don't know the extent of them. You always have to be cautious when you read these things. Is that just some fringe issue, or is that something that's literally taking hold? It would certainly be bad for potential clients who get someone who didn't take an entrance exam, didn't take exams, didn't take a bar. That would be a disaster. But a lot of these ideas that seem fringe 10 or 15 years ago are really coming into the mainstream now. So I think you've got to take all this stuff seriously. I think it's a bad idea. You've got to have some standards. You got to have exams in law school. You got to flunk out people who aren't doing anything or who don't understand anything. Otherwise, it's bad enough now. You go into court and it's pure chaos because judges don't understand the laws. Prosecutors are willing to dispense with the rules. It's bad enough as it is. We don't want it to be a complete free-for-all where people don't know anything and they just get in there and do whatever they want. I think it would be a disaster. So hopefully we maintain standards. And I know it's somewhat hypocritical for me to praise the bar exam because I didn't have to take one. Like I said, I don't feel bad about that because I did pass the CPA exam, but the bar exam is another way. It's less than perfect for sure, but it's another way to weed out people who don't understand basic law. So that's my take on it.
I just always remember a pupil of mine who is now a top lawyer in Edinburgh, an accordion pupil, and he was telling me about he went to Glasgow University to study law, and a student a couple of years previously was sitting one of his exams.
Yeah.
And several people obviously sit in the exam, and the exam was held up at 20 minutes at the start. Because the exam was in the afternoon, this student got up and demanded his right to a glass of port. and the invigilator had to go to the dean and say to the dean about this, and the dean sort of said, yeah, well, it's in the rules from about 1750 or something like that, So they had to take this port from the dean's office and take it to this student so that he could have his glass of port, because it
Oh
would
my
have been
God.
in the afternoon. It was supposedly for fortification, you see. So
Oh my
anyway,
God.
2 weeks later, the student got called to the dean's office, and the dean sat him down and said to him, "Well, I suppose you know why you're here." And the student said, "Well, yeah, for my prank in asking for the glass of port." And the dean said, "Oh no, nothing like that at all. You were perfectly entitled to your glass of port, but I am fining you a bottle of port for not wearing your sword and scabbard."
Oh. Oh my God, that's great. Oh my God. Yeah, it's been ages now, but people are there's a movie called The Paper Chase about law school. If people are interested in what law school is like now. When I went in the 90s, when did I graduate? Yeah, December 99. So I went in the 90s. There were still aspects of it like that, but I can remember once doing some type of a mock argument and I remember having a bottle of water, and the professor said, "Well, what are you going to do in court? Bring a bottle of water with you?" I thought, well, yeah, but no, that wasn't even allowed. I would have loved a glass of port, but yeah, things have definitely changed. I cringe to think what it's like today. With the newer generation can be very sensitive, and they have lots of demands that surprisingly are being met at universities. You always see these. I read the College Fix a lot. If people aren't familiar with it, it's a website about happenings in college and law schools, but mostly college. And there's always these demands. I mean, the idea when I was a college student or a law student that you would demand things of the dean or of the president of the university or something, it's outrageous. And today we demand all these things. And as long as you couch them, getting back to our original comment in terms of race, they seem to be, if they're not always met, certainly you're not smacked down. I mean, I would write a simple denied and send it back, but that's not the way it works today. So I don't know what law school is like today. I don't know how much they coddle students, but even when I went in the 90s, it was a little bit like the Paper Chase movie where we were put on the spot. You had to be prepared. They went out of if you weren't prepared, some would go out of their way to embarrass you because you have to come to class, prepared. I doubt it's like that anymore. Maybe some of your viewers have been to law school a lot more recently than I've been. I'd like to know what their experiences are.
Listen, pal, I'm going to let you go and take legal watchdog, the actual dog, on his constitutional, and hope you enjoy the rest of.
He's asserting his constitutional right to a walk is what he's doing.
Yes.
So I'm going to make sure he gets that today, and we're going to go for a nice stroll.
Excellent. Okay, it's been an absolute pleasure speaking with you, and I just can't wait to get you back for another chat.
Sounds good. We'll come up with another topic. And we'll do it again in a couple of weeks, and we'll sit around and shoot the bull. And next time we'll do it when I can join you in a beer.
Please do, because my glass is empty now.
All right. We'll see you soon.
Cheers, Mike. Thanks very much.
Bye.
Bye for now.